Chair.
The Honourable Amy.
Mr Chair, thank you. I'm just going to take a brief call. I've spoken already in this debate, but I wanted to touch on a couple of the SOPs that have been filed since we last debated the committee stage of the Judicature Modernisation Bill. Two in particular, I think, are new to the debate. The first is the SOP, which I understand is untabled. It's a tabled motion, Jacinda Ardern, seeking to effectively reinstitute the requirement for the mandatory publication of district court decisions. I just wanted to talk to that very specifically because, sir, there is very good reason why we haven't carried on with that obligation, which is that the district court is, of course, the workhorse of the New Zealand court system. And over the course of the year, it puts out something like 15,500 judgments, of which only a couple of hundred are written, considered detailed judgments. The vast majority, around 15,000 judgments every year, are oral, quick, sentencing-type decisions, simply a record of proceedings. And to put this requirement in law would be a requirement right across the system for every one of those to be transcribed, checked, formatted, gone through the peer reviewing and put online, which, sir, of course could be done. But as a question of resourcing within the justice system, you have to question what the value of that is. And when you are simply recording and transcribing straight sentencing notes that frankly are not of any precedential value, do not bind the higher courts, don't really inform the knowledge of law in our society, and are still a matter of public record, the very clear view that we've reached is that that simply isn't a good use of the time and resources we have in the justice system, which could be far better spent on much more predictive ways. If we were to do this, let me make it very clear to the House that those are important resources that aren't available for supporting, for example, better access to justice and more information for litigants and self-represented litigants and all of the other things that this House, I know, is very concerned to do. I would also point out to the House that the courts, the district courts now have a website, districtcourts.gov.nz, where they are publishing the decisions of relevance. So the decisions that this House has talked about the necessity to access absolutely are being published online and are accessible. Now, I think that's the right balance. We're getting the decisions up that are of use and of information to the system. We're not requiring, as a mandatory blunt tool, every single utterance of a judge at the end of a process to be treated with the same cost implication. So the government won't be supporting that amendment to the SOP. The second SOP that I want to touch on, which is new, is Louisa Wall's SOP, which she's just spoken about, around the appointment of judges and the need, or the desire to reflect in legislation the need to represent a gender and ethnicity balance in our judges. And I want to say that while I absolutely agree that it's important that our judiciary make up a mixture of our society, I want to say two things. First of all, there are already very clear protocols which ensure that in appointing judges, there has to be attention paid to ensuring that they represent a reflection of New Zealand society. That is already in the matrix of the decision-making that has gone through when judges are appointed. The second point that I'd want to make is that actually, if you look at the track record, particularly under the current Attorney General in the last few years, we have been extremely successful in seeing very good women judges appointed, not because of any quota system or making up the numbers, but because very good senior women lawyers are being recognised as excellent judges. Of the last 3 High Court judges appointed, 2 of them were women. Just very recently, we have had the head of every single judicial bench as a woman. The numbers of women being appointed under this government, while I don't have the numbers in front of me, I'd be very surprised if they weren't very heavily weighted in favour of women being appointed. So actually I would challenge that there is a demonstrable problem in this area. Yes, in terms of percentages, the member is right, but then look at the percentage of senior women in the legal profession. Having been in it for years myself, the problem starts there. And we know that there aren't enough women moving through to senior levels of the profession, and that of course means that there is a smaller pool available for judges to be appointed. But I think in actual fact, the actions of the Attorney General over recent years have shown very well that the protocols are in place and are working to ensure that the best judges are appointed and that they do reflect modern New Zealand society. I don't think it's necessary to codify that in a fixated way which suggests some sort of quota making up the numbers assessment. I know that as a woman, when I'm promoted, I want it to be on merit and not because there's some requirement for the numbers to be met. And I think, as I said, that the existing system we have absolutely reflects the need to ensure that judges make up a cross-section of society, and that, sir, is working very well, and so the government won't be supporting that SOP either.